Hello, and welcome to Hospice Insights, the law and beyond, where we connect you to what matters in the ever-changing world of hospice and palliative care. The new 60-day repayment rule. What's new? What's the same? What does it mean? Hey, Andrew, how you doing? Welcome to our Hospice Team podcast.
Hey, Ryan. Great to be here. Thank you so much.
Yeah, always nice to have you. You're kind of our go-to guy for a lot of investigations, regulatory work. You're doing, compliance stuff with those PPEOs and suspensions that are everywhere. You're the, what do they call it in baseball? The utility man. You can do
Yes.
everything. So
Jack of all trades.
yeah,
Yeah.
and I always enjoy hearing from you because you have a real depth of thinking about these issues that I find very interesting in how you review these items, how you come up with real practical ways to turn that knowledge into something hospices and our clients can make use of. So I've been looking forward to this.
Awesome. Well, it's
Welcome.
very kind of you. Thank you, Brian. Yeah,
Great.
should be an exciting conversation.
Yes, and it relates to something that you can do a deep dive into this area of internal investigations and the 60-day repayment rule. And you can get into a lot of legalese because it implicates the False Claims Act and legal terms like reckless disregard. What does the word knowingly mean? It kind of cries out for, an attorney's playground of language and all that. But hospices have to deal with issues like overpayments and what are their obligations when they identify an overpayment. And it's not practical for them to always run out to an attorney. I mean, it's advisable, I think, to touch base and get some insight, but we're all about letting hospices do the work that they do well, and that includes a lot of times compliance issues. So so let's talk about the 60-day repayment rule. It's been around for a while, but there's been a change that, Andrew, I think you wanted to highlight. Why don't you
Yep.
kind of take us through what was the old and what is the new, in a way that hospices should keep in mind?
Great. Yes, absolutely. So yeah, the CMS did relatively recently update the 60-day repayment rule. Kind of like you said, there's some new things. There's some things that didn't really change. So kind of at a high level, um, the one thing that I guess did change is what we kind of call the identification standard. So once you identify an overpayment, right, you have 60 days to return that overpayment. That's actually a statutory requirement. And it's in this Medicare 60-day repayment rule that CMS kind of fleshes out what that means. So under the old rule, essentially there was, I guess, a lower standard for triggering that identification 60-day requirement. As the result of some lawsuits or a lawsuit that was filed by some Medicare Advantage plans, the I guess the federal court determined that that previous standard, which was based on negligence, which kind of a lower legal standard, was unlawful in terms of imputing False Claims Act liability. So there's kind of a heightened standard now relative to the old rule in order to truly identify an overpayment for purposes of triggering the repayment obligation. A provider now has to know that there was an overpayment, which means one of several things: actual knowledge that the overpayment exists, um, acting in reckless disregard of whether or not the overpayment exists, or acting in deliberate ignorance of whether the overpayment exists. So no longer kind of a lower negligence standard, but it has to be a little bit more before you have to, you trigger your obligation to make a repayment. So
Yeah,
that's
and
one
I think
big
no,
change.
yeah, go ahead. I didn't mean to cut you off.
No, no, no.
Yeah, and so I mean, all this comes in the context of the False Claims Act. I mean, it's really derivative of that through the 60-day repayment rule, providers have this obligation when they know they got paid, for something they shouldn't have gotten paid for, they got to give it back to the government. And the False Claims Act has some serious penalties to it. So if you fail to do that, it's like triple the amount you received, attorney's fees, and kind of on and on. And because it's such a big, such a such a hammer that the government has, you have to do more than just show that negligence, which is what the old 60-day repayment rule seemed to allow. It's this
Exactly.
whole knowingly standard. The False Claims Act doesn't go after honest mistakes or simple compliance issues.
Right.
So yeah, I remember when those cases came out and the court said, you can't just implement the 60-day repayment obligation based upon lack of reasonableness, which is another way of saying negligence. It's got to be more than
Absolutely.
that. But and kind of going back to you mentioned identifying the overpayment. What are some situations that we've encountered? I mean, how is an overpayment identified, and how does that come to our attention?
Yeah. Many different ways. A common way I would say is kind of audit results. So if you have like a UPIC or a Mac reviewing some of your records because you had to submit them through an ADR, and they come back and issue claim denials because, let's say, your certification was late or you missed a face-to-face. If that issue sort of is a kind of a systemic issue. It isn't sort of like a one-off mistake. That can be considered kind of having knowledge that there might be a potential overpayment with respect to similarly situated claims. So if the late certification was due to a process issue, or if the missed face-to-face was due to a process issue, or let's say you had a nurse that you discovered was unlicensed. This kind of comes up a lot. This, I guess, wouldn't necessarily be like an audit situation, but let's say your HR team finds out that you had a nurse that was, doing discipline visits for many months. That can trigger an overpayment or a repayment obligation because there is a condition of payment that you have to provide services in accordance with the care plan, which would include visit frequencies. We've also seen kind of like if you have third-party consultants that you hire to kind of do some auditing, they can find kind of issues that can sort of imply some systemic bigger thing is going on that, could again trigger this repayment obligation, which, as we can get into here, does have there's kind of an investigation period that you're afforded under both the old and the new 60-day repayment rule.
Yeah, so external audits, internal audits, the complaint hotline that hospices should have. I think that's recommended by CMS. Maybe somebody calls in and identifies a problem, but all sorts of different sources can lead a hospice to conclude, well, this implicates a condition of payment. We dropped the ball. We screwed up. We think we now have to pay some money back to the government. Let's look into this. And you mentioned this investigation component of the 60-day repayment rule. Why don't you kind of describe that and the timeframes
Yeah,
that apply to the repayment? I mean, we call it the 60-day repayment rule, but that's too simple of an answer, unfortunately.
right,
There's more
right.
to it than that. Kind of scope that out for us.
Exactly. So yeah, it's 60 days is how long you have to make a repayment once you know that there is a repayment. So kind of that identification standard. And actually, I'll insert here that if you're a provider that does cost reporting, like hospices, home health agencies, technically it's the later of 60 days from identifying the overpayment to the due date of the cost report. So like if the whole overpayment occurred within like the current cost reporting year, for example, you could have until May of the following year actually to make your repayment. So in that way too, it's sort of the 60-day repayment rule is a bit more complicated than 60 days. But additionally, again, you're afforded an investigation period. So, and under the new rule, it sort of distinguishes between the initially identified overpayment and then related overpayment. So, you know, overpayments that are the result of sort of the same or similar issue or cause as the cause of the initially identified overpayment. So, so you have the 60 days, and then under the new rule, you have up to 180 days to conduct your investigation. Once you know, for example, that you have an overpayment, it is important to get started on that investigation right away so that you can, sort of buy yourself more time to really get to the bottom of whether this is an isolated issue or whether it's more systemic, kind of a bigger issue that may have related overpayments involved as well. So once you finish that investigation, then you'll have the remainder of, your 60 days to kind of go ahead and make your ultimate repayment after you've quantified everything.
So a couple of examples, let me throw these at you. Let's say through an internal audit, and unfortunately, this is a hospice that didn't do a pre-billing audit. They're kind of reviewing things after the fact. They come upon a certification, and the doctor failed to sign it, or it was not a legitimate electronic signature. And you don't have any reason to think this is anything but a one-off. So if that's what they came across, you think you've concluded, maybe you have arguments, but you conclude, well, we're going to make a repayment. Is that a 60-day? Is that a 180-day investigation? What category does that fall in?
That would be the 60 days. Again, kind of under that hypothetical, we don't think there is any related overpayments, and the purpose of the investigation under the new rule is focused on the related overpayments. So in that example, you would just have the 60 days or kind of that cost reporting exception thing. Technically, you would have until the end of the corresponding cost report period, the due date for submitting the cost report for that period.
So a slightly different example. You have a certification, it's signed by the physician, so that's not the problem. But on the pre-printed certification form, there is no statement that says, I composed this narrative based upon my review of the patient record or examination of the payment. It's just gone, not part of the form. And you use an EMR, so it's kind of a standard form. Where do you think, how would you categorize that? Or what do you think the timelines are for that?
Well, that is an unfortunate issue to have discovered because, yeah, likely all of your certification forms are going to be impacted by that kind of systemic built-in EMR issue. So definitely, I'd say the likelihood of related overpayments. So once you identify that overpayment, right, you have 60 days. If you start the investigation immediately, like on day 0, then you have 180 days, up to 180 days. I mean, you shouldn't sort of dilly-dally, kind of get started on the investigation so you can maximize your time. But you would have 180 days. Then again, assuming you started the investigation immediately, you would, at the end of that up to 180-day period, you would have up to 60 days to repay, or again, with the cost reporting exception.
Yeah, and I guess let's hope in that investigation, this was a limited glitch in the EMR that didn't affect every single document, or maybe the doctor has at times wrote in certain acceptable language. I think those are all circumstances, Andrew, you and I have encountered where in the course of an investigation, you find issues like that help limit or, maybe they even expand what you're talking about. You got to go where the facts take you. So
exactly. And that's why it's so important to have kind of the most amount of time as you can for the investigation, because oftentimes, we can come up with creative but credible legal arguments to kind of mitigate the overall repayment amount.
Okay. So I think that's a significant change, the whole how you identify and then the time frame, how that's calculated. What has stayed the same with the 60-day repayment rule?
I think that the biggest is the 6-year look back period. So Again, we're talking about Medicare overpayments, which are the only types of overpayments that are subject to the 60-day repayment rule. Um, for Medicaid overpayments, they're still subject to the statutory requirement to return overpayments within 60 days. But in terms of the Medicare rule, we have a 6-year look back period. We have always had a 6-year look back period. So, and again, that's getting at, in terms of your obligation to return identified overpayments, that applies, 6 years into the past. So you're not expected to go hunt down every, potential overpayment related to kind of the same issue indefinitely back in time. The sort of cap at 6 years, and that was the case, and that still is the case.
All right. So what kind of words of advice or guidance can you provide to people as they're beginning this journey into the 60-day repayment rule? They found something that they think is an overpayment. What are some general steps
Yeah.
or pointers you can provide to them?
Well, I do think it's often very helpful to engage counsel, not to sound self-serving. I mean, to your earlier point, it's not always required or even necessary, but oftentimes it can be very helpful. We do a lot of this work. We oftentimes can kind of come up with creative arguments or just ways to kind of think about things. And then also, privilege, right? We, kind of the communication we do with you under engagement is protected by the attorney-client privilege. Mentioned this earlier, act promptly, especially under the new rule, where, that you have the 180-day investigation period, but technically you only have that up to 180 days from the date that you identify the overpayment. So it is really important to get started on the investigation right away so you can kind of make full use of that 180-day period, plus have the 60 days at the end of that. And again, you probably don't want to use the full amount of time if, you reasonably don't have to, if the investigation can be done quicker. And then, as always, this kind of documenting everything is very helpful. You want to 5 years from now be able to kind of understand the decisions that were made, kind of what your process was. If you did rely on repayment arguments to kind of, minimize the repayment amount, you want to be able to kind of fully articulate that. So having contemporaneous documentation is very helpful. So those are kind of the high level words of wisdom, I guess.
Yeah, I think, we know with auditors, they can go back 4 years. So some of these things may not come up for years later. The statute of limitations for the False Claims Act is 6 years or 10 years, depending upon the kind of violation it is. So yeah, it's important to have that institutional knowledge because there's turnover. Now nobody has the perfect memory. And your point about engaging legal counsel or at least speaking to them. I know, on a number of occasions, I'd get a call and I'm able to walk somebody through the highlights of an investigation and in an hour, and they're kind of comfortable moving ahead on their own. And so an hour consult is enough. And Andrew, I know you get involved in very complex investigations where you are taking the lead necessarily because it's just requires a lot of legal analysis, but it can be anywhere in between those two poles.
Absolutely.
So now you've developed a tool here to help sort all this out because even in our brief conversation, a lot of jargon has come up. It's clearly a complex area. So what have you developed to help our clients out?
Well, we have a very handy one-page handout that is available on our website. I think it's going to be included in the podcast materials as well.
This has got to be, what's the cost? Is it $1,000? Is it $2,000?
Yes, it's $2,000. No, it's free, of course.
What a deal. What a
Yes.
deal.
Exactly. So yeah, it's just sort of intended to be kind of a quick reference guide here, kind of summarizing essentially what we've been talking about, but in a more, I think, practical and a kind of compliance, officer friendly, focused version of what we're talking about. So it kind of gets into the different time frames that you have to worry about, kind of what triggers the different events and the corresponding time frame. It kind of gives a couple of examples of kind of how an investigation might kind of proceed and what the different time frames would be for kind of those two examples. So again, it's kind of a one-pager quick reference that I think will be helpful for compliance teams.
Great. Well, you're chewing into our team's profits here, Andrew, by not marketing this at its full value. But we love helping our clients and hospices, and this is can be a quagmire. It can be confusing. I think I took a look at that one pager. I think it really clearly lays out all the key elements and the time frame. So if you're ever encountering this situation, you can start to calculate, what are your deadlines? What do you need to do by when? So you try to stay compliant. So thanks for putting that together.
Yeah, you bet.
And thanks for the podcast, Andrew. Appreciate the time and the subject matter. Very important stuff. And everybody who's listening, you'll be able to access that free form, that free one-pager in our episode notes. So feel free to go there and download it and make use of it. And Andrew and I and our whole team, we're here to answer any questions you have. So thanks for listening and take care.
Thank you.
That's it for today's episode of Hospice Insights, The Law and Beyond. Thank you for joining the conversation. To subscribe to our podcast, visit our website at hushblackwell.com or sign up wherever you get your podcasts. Until next time, take care.